Welcome, y'all. I'm the loud little ducky. Today we are going over some more Owens v. Echard. This train does not stop. Apparently, Gingras and Owens have objections to attorneys' fees and costs. To pay or not to pay? That is the question. Filed July 29th, 2024 in the Maricopa County Superior Court, State of Arizona. Gingras, attorney for the petitioner Owens, in the Owens v. Echard matter, petitioner's response/objection to respondent's application for attorney's fees and costs. Let's see what objections they have. Introduction. This case is currently in a difficult and unfortunate posture. As a result, this brief is almost certainly futile because no matter what is argued herein, Clayton has either already won the issue or he has already lost. We just don't know which it is yet. As the docket reflects as of today's date, there are two pending unresolved matters. A. Laura's notice of change of judge for cause, which was filed July 8th, and B. Laura's motion for a new trial and other relief filed on July 12th of 2024. Both filings raised the same central issue, misconduct by the trial judge, which violated Laura's right to a fair hearing. Based on that issue, among others, Laura has asked for an order disqualifying the currently assigned judge, which is the Honorable Judge Mata, and ordering a new trial. These requests are essentially overlapping. If the disqualification request is granted, a new trial is probably automatic, thereby mooting the current fee application. On the other hand, if the disqualification request is denied, the outcome of Clayton fee application is a foregone conclusion. Due to this unusual posture, the belief is unlikely to have any effect on the outcome of this litigation, except to the extent of any of the issues may need to be raised later on appeal. Accordingly, this brief will present Laura's arguments in the abbreviated manner solely to ensure non-waiver on appeal. So he's doing this for appeal purposes, and he just sounds cocky. Discussion. While considering the issue of fees, it is important to stop and note the context of the case involving a petition to establish paternity filed pursuant to ARS 25806. Which such a petition is filed, there are only two possible outcomes. 1, paternity is established, or 2, paternity is not established. Although the parties vigorously dispute the question of whether Laura has ever actually pregnant, two key factors are entirely undisputed. 1, both Laura and Clayton were pro se from the day this action was commenced on August 1st, 2023 until mid-December 2023. And number 2, Laura moved to dismiss the case with prejudice on December 28th, 2023. This timeline is crucial to understand the fee issue, so the relevant dates are depicted in the diagram below for clarity. Point A, the petition is filed on August 1st, 2023. Point B, Woodnick appears December 12th. Point C, Laura moves to dismiss 12/28/2023. And point D, the trial, June 10th, 2024. As this diagram shows, it is an undisputed fact that between point A, commencement of the action on August 1st, 2023, and point B, when Clayton's counsel first appeared on December 12th, 2023, neither party incurred any legal fees because both were pro se, is probably what he's going to say, but I don't think that matters because there's filing fees and things like that, if I'm not mistaken. Parties were pro se. Despite this, Clayton fee application shows substantially all fees he is seeking were occurred between point C, which was when Woodnick hopped on the case, and D, which is the trial, which, as explained below, was completely unnecessary as a matter of law. Okay. Also undisputed are two other key facts. First, prior to the filing, a motion for leave to amend on December 12, 2023. Clayton's counsel, Greg Woodnick, violated Rule 9C of the Rules of Family Law Procedure. Mr. Woodnick violated Rule 9 by bringing a motion without making any attempt to meet and confer with Laura to determine her position. Well, we made it to the top of page 3 before he started bringing up her sanctions and stuff and motions to dismiss and all of that nonsense. Okay, sanctions haven't been done. This is just the motion to dismiss. He didn't give her the 10-day notice. This leads to the second key fact. Immediately after Woodnick appeared, Laura's first step was to file a motion to dismiss with prejudice on December 28, 2023. That fact has been largely and almost entirely ignored by Clayton's counsel and by the currently assigned trial judge because there were still things to go forward, and this case was not going to be terminated. And she continued to lie even after the motion to dismiss with prejudice. She continued to cause fees to occur in this case. Any right Clayton may otherwise have had to seek fees after that date. Put differently, Clayton presents fee application seeks an award of $154,000+ in fees and costs incurred for the purpose of defeating Laura's petition to establish paternity by proving she was not pregnant. But Laura's motion to dismiss unequivocally admitted that fact. The second line of the pleading stated petitioner is now pregnant with respondent's children. Motion to dismiss filed December 28, 2023 at 1:19. Saying that she's not pregnant by that date doesn't mean that she wasn't not pregnant before those dates. And it still doesn't prove, like, it's not her admitting that, okay, I'm not pregnant, but that's not her saying that when I was fake pregnant, it was with my fake babies were Clayton's. That was still disputed. So, viewed in that context and putting aside his counsel's violation of Rule 9C, if Clayton was entitled to any fees at all, which he is not, the only time period involved would be between B and C, i.e. from December 12th, when Mr. Woodnick first appeared, until December 28th, when Laura moved to dismiss. No fees may be awarded prior to B because Clayton has no fees prior to then, and no fees may be awarded after point C because by that date, Laura withdrew her claims or tried to. Yeah, she tried to get out by making up another lie. It just didn't work. But go ahead and state all your stuff for appeal. Of course, because Mr. Woodnick was required to meet and confer with Laura, if he complied with that obligation, he would have learned by making a single phone call that Laura was no longer pregnant and that all paternity issues in the case were moot. No, they weren't, because she's still lying and saying that those were his babies when they were not. So it wasn't a moot point just because she no longer wanted to play pregnant anymore. So to recap, even assuming Laura was never pregnant at all, it is undisputed Clayton did not incur any fees between points A and point B. It is further undisputed that Clayton would not have incurred any fees after point B if his counsel had simply complied with Rule 9C by contacting Laura and asking for her position. We don't care about her position. We want this case to say what it said at the end. What Mata said it said, if that makes sense, is what we wanted it to say. We don't care whether she was done pretending. Clayton wanted his name cleared, that he was not the father of those babies and that she lied and lied and lied and continued to lie. And her fees wouldn't be so much if she would have told the truth a time or two. Mr. Woodnick cannot and should not be rewarded for ignoring a mandatory procedural rule in this manner. I believe that Woodnick pointed out to you when he notified her, and it was past those days. A. Clayton is not entitled to fees for litigating a moot claim. In her motion to dismiss, filed 12/28/2023, Laura explained she was no longer pregnant. and thus any paternity establishment issues were moot. Well, that's what you think. It is well established that courts cannot decide moot cases. Well, they could figure out who was the father of those babies prior to her supposed miscarriage, absorption, whatever she wants to call it in her make-believe play. And then he's got some sightings from a 1985 case. That single fact preludes any awards or fees incurred after December 28, 2023. So basically, he wants him to have 22. He wants him to only get awarded 16 days of fees, which is from point B to C. 16 days. That's all that Gingras is saying that he should owe. 16 days between December 12th and December 28th. Court of Appeals has repeatedly held we are not a fountain of legal advice, and we will not decide a question which by a change in condition or affair has become moot. And that's in a 2024 court case. Issues are moot when our action as a reviewing court will have no effect on the parties. Well, her lying about him being the dad has an effect on the parties, and her calling him a deadbeat dad. Here it is undisputed Laura admitted as of December 28, 2023, she was no longer pregnant. Had Clayton's counsel complied with Rule 9C, as he was mandated to do, Laura would have made that admission even earlier. Clearly, as a matter of law, Clayton is not entitled to recover $150,000 in fees for the purpose of proving that Laura was not pregnant when that issue was entirely moot before those fees were ever incurred. No, we wanted to prove that she was not pregnant as of August 1st. Not in December. As of August 1st when she brought this. The fact that in the meantime she became not pregnant did not mean that that whole thing is moot, because she's still claiming she was pregnant up until that point. B. Clayton is not entitled to any award of fees because his counsel violated Rule 9C and failed to provide the safe harbor requirement by Rule 26. Here we go, Rule 26. That's his whole Rule 26 thing. It is about Rule 26 and their sanctions. He mentioned it in page 3. It's all connected. On May 10th, 2024, Laura filed a motion for judgment on pleadings. In that motion, she argued Clayton was not entitled to sanctions as a matter of law because his counsel failed to comply with the procedural requirements of Rule 26. Sir, how many times does a judge have to say the Rule 26 is moot? You keep talking about, oh, this is moot and this is moot. Rule 26 is moot. It was on the table, then it was taken off the table, and the judge did not make Rule 26 findings in her sanctions and attorney's fees. She still hadn't even ruled on sanctions, technically. She just ruled on attorney's fees. Her sanction was, we're turning you over to the DA's office. The motion further argued this error could not be fixed by trial court sua sponte, converting the defective sanctions motion into one seeking relief on some other basis. But you stated in your motion that the judge could sanction on other basis. That has nothing to do with Rule 9C or Rule 26. Let's continue. We reject Rainbow's argument that the district court's order for sanction can be interpreted as a Rule 11 motion on the court's own initiative, pursuant to Federal Rule Civil Procedure 11C1B. This provision does not require 20-day advance notice. We reject Rainbow's contention because it was Rainbow, not the court, that initiated the award of sanction. The district court discussion of the safe harbor provision in its order concerning sanctions serves to emphasize this point. It would render Rule 11C1A's safe harbor provision meaningless to permit a party's non-compliant motion to be converted automatically into a court-initiated motion, thereby escaping the service requirement. Because Rainbow did not follow the mandatory service procedure of Rule 11C1A, we reversed the award of sanctions. Great. But that is not what we have here. And the Rainbow thing was a Ninth Circuit case in 2001. Here, the trial court simply ignored this rule and awarded fees to Clayton, despite the fact it is undisputed that Clayton never provided Laura with the required written notice of her absolute right to withdraw her petition without consequence. In this way, the court deprived Laura of the safe harbor rights to which she was entitled under Rule 26C. Sir, this point has been argued to death. Similarly, the motion for judgment on the pleadings explained any request for fees and sanctions would be untimely because the alleged violation here was based on Laura's act of filing this case on August 1st, 2023, without a sufficient factual basis, allowing Clayton to incur $150,000 in fees between 6 months and nearly a year after the date is entirely inconsistent with the purpose of rules permitting sanctions and or fees for such conduct. And then it's got a 2023 Arizona appeals thing, cleaning up, requiring prompt action by a litigant whenever a Rule 11 violation appears, because promptness in filing valid Rule 11 motions will serve to foster efficiently. Denying as untimely as a matter of law a Rule 11 motion more than 17 months after the offending conduct. It is an unpublished memorandum decision by the Court of Appeals as such pursuant to Arizona Superior Court Rules 11-1C1C. It is cited for persuasive value only because no other published opinion adequately addresses the issue. C. Fees cannot be awarded for tort-based counterclaims. The record in this case is clear. Laura learned she was no longer pregnant in mid-November 2023, and after making that discovery, she filed nothing further in this case. Due to the lack of the case activity on December 4th, 2023, court administration issued a notice placing this matter on inactive calendar and stating the matter would be dismissed in early February if no further action was taken. Had no further action been taken, this case would have been dismissed without Clayton incurring a single penny of legal fees. Despite this, Clayton opted to retain counsel for the purpose of amending his response to Laura's petition to affirmatively assert a claim that Laura was never pregnant at all in this case. Exactly. Yes, in this case, period. Not just after she was done lying, but way before that. So it doesn't matter if she's not pregnant now, she was not pregnant then either. That was the whole point. And I think you missed that. As has been explained in other pleadings, the family court has no subject matter jurisdiction to decide non-paternity tort claims such as fraud, defamation, or malicious prosecution, which is what Clayton's amended response to petition effectively sought to raise. However, even if the court had jurisdiction over the tort issues, the court cannot award attorney's fees for Clayton's efforts to litigate those claims. This is so because Arizona law generally does not permit recovery of attorney's fees in intentional tort cases, including where such claims merely sound in tort. See Gitman v. Simpson, 2021. Attorney's fees are not available in defamation actions as a general rule. See Barmat v. John and Jane Doe Partners A through D, which was from 1987, rejecting argument that legal malpractice plaintiff could recover attorney's fees on a negligent claim because Arizona law generally forbids fees awarded in tort cases. The legislature clearly did not intend that every tort case would be eligible for an award of fees. And then Ramsey Air versus Qatar Aviation, 2000 case, negligent claim against pilots sounded in tort and thus could not support an award of attorney's fees. Here, Clayton's allegations against Laura sound in tort. They accuse her of committing fraud and other intentional torts. That was in discovery, though. I mean, yeah, she lied about being pregnant because she was trying to take him to court on this. So we needed a ruling on whether she was or was not pregnant when this case was first filed. And the fact that she committed other things in the middle of this case, that just means Clayton can go after her again for other things. So it says, which it does not, Clayton cannot recover fees. Under ARS 24809G for litigating those claims, because the only claims remaining after mid-December 2023 were counterclaims that sounded in tort, not paternity claims arising under Title 25. D. Clayton has failed to show his fees were reasonable. Okay, let's see what you got. Because Clayton is not entitled to the award of any fees at all, it is not necessary to determine whether the amount requested is reasonable. However, if that issue was considered, it is clearly the fee sought by Clayton's counsel is not reasonable under the controlling standards of ER 1.5. The rule provides a lawyer shall not make an agreement for charge or collect an unreasonable fee. See also in the matter of Swartz, which is a 1984 case, we hold blank that if at the conclusion of lawyer's service it appears that the fee which seemed reasonable when agreed upon has become excessive, the attorney may not stand upon the contract. He must reduce the fee. And that was in 2007, explaining notwithstanding the general rule that attorney's fees are enforced in accordance with the terms of a contract or contractual provision, providing for an award of unreasonable attorney's fees will not be enforced. That was from 1965. To meet his burden, Clayton's counsel must show the fee requested is reasonable in light of the factors set forth in ER 1.5 as follows. ER 1.5 fees. The factors to be considered in determining reasonable fees of a fee included the following. 1. The time and labor required, the novelty and difficulty of the question involved, and the skill required to perform the level service properly. 2. The likelihood, if apparent to the client, that the acceptance of the particular employment will preclude other employment by the lawyer. 3. The fee customarily charged in the locality for similar legal services. 4. The amount involved and the result obtained. 5. The time limitation imposed by client or by the circumstances. 6. The nature and length of the professional relationship with the client, which we have. We have times that when the labor and how much labor was put on each of those charges. The experience, reputation, ability of the lawyer or lawyers performing the service, which he gave that. 8. The degree of risk assumed by the lawyer. Here, the affidavit of Clayton's lead counsel, Greg Woodnick, fails to mention, much less address, any of the controlling factors of ER 1.5. However, indirectly on pages 3 through 4 of Woodnick's affidavit, he provided some background biographical information, which includes some volunteer work and teaching work. While certainly laudable, nothing in Mr. Woodnick's affidavit supports his claimed hourly rate of $650, which is nearly double the average and median rates for family law attorneys in Arizona, according to the State Bar of Arizona's most recent Economics of Law Practice Survey report. When was this report from? A copy of which is attached herein as Exhibit A. Footnote 2 says undersigned counsel is currently serving a 3-year appointment as an arbitrator with the State Bar of Arizona Fee Arbitration Program. In that capacity, the undersigned has received special education and training in the area of determining the reasonableness of fees under ER 1.5. In addition to other tools and evidence, all State Bar fee arbitrators have been advised to refer to the Economic Laws of Practice Survey report when determining the reasonableness of specific fee requests. So it's got a bunch of respondents, the average, the median, and the base. And so Gingras circled family juvenile law, average is 329, and the median is 329. So, So apparently he should be charging $3.29 and not $6.50 an hour, according to Gingras. This point is underscored by the fact that Mr. Woodnick's stated rate is indeed only $3.25 as listed in attorney roster maintained on the Superior Court's website. Greg Woodnick hourly rate in family and divorce is $3.25. Okay. So the thing is just because Woodnick submitted what he charges as being hired as a private attorney, doesn't mean that the court has to agree on all those attorney fees. She could say, no, okay, so everywhere where you said $6.50, I'm going to bump it to $3.25. Is that still technically a little win for Owens and Gingras? Yeah, because they're not going to have to pay out as much. And so, I mean, he does need to do this for appeal, but it's zealously advocating for your client because you want to try to get that bill as low as possible for your client. We saw this in the Maya Kowalski case where some of the charges were a little extreme, some of them were not. And they reduced several, might have been tens of thousands, I don't think it was hundreds of thousands, just off of the bill, which isn't much when your bill is like in the millions, but for $150,000, taking half of those off or splitting some of those hours in half, that's going to save Owens a bunch of money. Do I think she should have to pay out the wazoo? Yes. But, Gingras is doing his job, and we have to give him props for doing his job on this part, like he did his homework. And that may work in their favor. It may not. It just depends. So, it's got the link and it shows this page. To be sure, just because $3.29 an hour is the average rate for family law attorneys in Arizona, and just because Mr. Woodnick advertises his rate as $3.25 an hour, does not necessarily mean that $6.50 an hour would always be unreasonable for a lawyer with suitable experience, skills, and qualifications. However, nothing in Mr. Woodnick's affidavit supports the amount he requests, nor does he demonstrate that he is entitled to double his normal rate in this case. I think dealing with your client and the accusations that she has caused towards him and two clients he has had with Owens, I think it does, but that's just my opinion. Among other things, Mr. Woodnick makes no reference to any court ever finding that $650 an hour is a reasonable fee, given his specific experience, reputation, and ability. Indeed, Mr. Woodnick's affidavit makes no mention of any significant past litigation experience that would elevate his rate beyond an average amount. Furthermore, independent research by the undersigned revealed that Mr. Woodnick's litigation experience in higher level cases is virtually non-existent. For instance, a diligent search reflects that despite his 20-plus years as an attorney, Mr. Woodnick has never participated in any matter resulting in even a single published or even unpublished legal ruling in any court where in the United States, either at trial or appellate levels, a search for Greg Woodnick in LexisNexis literally produces zero results, nothing. So I saw something on this when I was trying to catch up from vacation and seeing what all has happened. Somebody did post something about searching Greg Woodnick and LexisNexis literally produces zero results, nothing. And it was a search in LexisNexis that did produce stuff on Greg Woodnick. But what Gingras is saying here is that nothing in LexisNexis is there that shows attorney's fees being that $650 rate or that would cause a $650 rate. I could be wrong because I haven't fully looked at that, but that is what Gingras is saying here. Not that there's nothing in LexisNexis on Greg Woodnick. It's that in this category of the 650 attorney fees and things like that, there's nothing pertaining to that in there. If I am wrong, I will go back and correct it. But I read this with y'all first time, so I have first reactions with y'all. Continuing on, by comparison, during a career of similar duration, undersigned counsel has participated in hundreds of matters across the country, including numerous high-profile cases resulting in dozens upon dozens of published and unpublished rulings in the state and federal trial courts and state and federal appellate courts. And it says, see examples from 2022 Ninth Circuit, granting a temporary restraining order in Maricopa County and First Amendment case in favor of a reporter from the Gateway Pundit. And then it just continues to list more and more cases. Continuing on in more cases, then it says approving fee award to undersigned counsel as reasonable. To be sure, the existent or non-existent in Mr. Woodnick's case of substantial trial and appellate experience does not, standing alone, determine whether an attorney fee is reasonable. However, the failure of counsel to demonstrate any basis for an hourly rate that is nearly double the average prevailing rate for family law attorneys in Phoenix is dispositive. Well, I would like to know how much you charge, Gingras. Because I think your greedy butt charges probably higher than the average rate too. Or maybe you charge less. Because, well, just look at you. Okay. The court cannot and should not find the fees requested by Clayton's counsel are reasonable, not because the fees are conclusively per se unreasonable, but rather because counsel has failed to meet the burden of showing the fee meets the requirements of ER 1.5. So he says whether it is reasonable or not reasonable, he didn't state the basis, which is a requirement that you need to state the basis for this, and he did not do so. That's what's being said here. E. The requested fees and costs were not necessary. Before any fees and costs may be awarded under ARS 25809G, the court must find those fees and costs were necessary to the outcome. Here, the post-trial minute entry does not contain any finding that any of Clayton's fees and costs were necessary, nor is there any basis for such finding. Excuse me, come again. I think a lot of it was necessary, and a lot of it was because of you and your client. All of your yapping that you did, because a lot of things just amped up after you came on. So a lot of it was necessary because she kept lying. And we had to keep disproving lie after lie after lie. I guess you don't think they're necessary because if he didn't do any of that, well, then you wouldn't be in this position. And your client would have won. But in order to win and prove her as a liar, it was necessary, in my opinion. But let's see what he says. As noted above, it is an undisputed fact that after learning she was no longer pregnant in mid-November 2023, Laura filed nothing further in this matter. You already stated that. Why are you stating it again? And she did nothing to keep the case alive. It is further undisputed that before Clayton's counsel appeared, the case was scheduled for administrative dismissal due to inactivity. Against the backdrop of undisputed facts, there is no good faith basis to argue that it was necessary for Clayton to incur any fees or cost in the defense of this action after the matter was placed on the dismissal calendar. Well, Clayton didn't want it dismissed because he still wanted to point out that she lied when she filed this. And so, yeah, it is necessary to continue this case to prove that. To be sure, Clayton's desire to use this case for purposes of publicity and his counsel's wish for personal revenge against Laura may explain their efforts to keep this case alive as long as possible. Just because you and your client like revenge doesn't mean that Woodnick and Clayton are out for revenge. And publicity? Are you kidding me? Your client is the one who went to the media. Your client is the one that keeps pushing things out in the media. Clayton has put his say in, but not until after she went to the media and started all this. So it's not for publicity. It's to clear his name because your client was trying to get publicity in the woe is me category. However, those actions which constitute actionable abuse of process under the Court of Appeals decision in Crackle v. Allstate Insurance, which is a 2004, do not mean that any of the fees incurred were necessary to resolve the established petition filed by Laura. Because such fees and costs were not necessary, and because there has been no finding on that issue, Clayton is not entitled to any award of fees or cost. Conclusion: for the reasons stated above, Clayton's application for fees and costs should be denied in its entirety. Dated July 29, 2024, signed David Gingras, petitioner for Owens, and copies were sent to the proper people. So that is the end of that motion. Gingras has to make the argument or he can't bring it up on appeal. But let's end this with our quote of the day. The best apology is changed behavior. We know that Owens is not going to be apologizing, but if she wanted to apologize, what would be best would be her changing her behavior and not doing this to any more men. Or apologizing to the DA because you are trying to get a better deal. The best apology to Maricopa County and in California is to change your behavior. Get the help you need and quit doing this because it's not working for you. It has only gotten you in more and more trouble, and it's been going on for 10 years and it needs to be done. But if you owe somebody an apology, saying sorry is great, but make sure that you change your behavior and don't do the thing that you're having to say sorry for again. Don't cheat, don't lie, don't break trust, don't break promises. Change your behavior. It was good being back to making more videos, and we have more coming, but I hope you all have a good evening, and I will see you in the next video.